All right, well, welcome back. Again, my name is Dakota Rudesill, and I'm a law professor here at The Ohio State University, the Moritz College of Law, and I'm a senior faculty fellow at the Mershon Center for International Security Studies, and we're just delighted that all of you are here today. This is the fourth and final panel of our conference today on 9/11 at 20 years. And we will be focusing today on the legal legacy of 9/11 and the post 9/11 period. I want to say a special welcome to our Moritz College of Law students who are in my National Security Law and Process class, for whom this is a command performance. This is during our regular class session. They're here. We're delighted that they are, and I just want to remind them that they're all most welcome and encouraged to participate during the Q&A. To help us understand a matter as expansive, as complex, and impactful as 9/11's legal legacy, we have the help of three of the law's brightest lights. Liza Goitein is Director of the Liberty and National Security Program at NYU Law's Brennan Center for Justice. She is a prolific scholar on presidential powers, legal secrecy, and other matters. And frankly, just does a great service to all of us who are scholars in this area and to the general public when it comes to national security law. So welcome, Liza. We're also delighted to be joined by...
I was trying to say thank you and I forgot to unmute myself. Thank you, Dakota. Pleasure to be here.
So noted, and thanks so much. Great to see you. Also delighted to have with us Peter Shane, my senior colleague here at the law school, recently Emeritus Professor of Law at the Moritz College of Law, a longtime Mershon Center affiliate and fellow, and a nationally recognized scholarly leader regarding separation of powers, which will be the focus of his remarks today. Thanks so much, Peter.
Great to be here.
And Sahar Aziz, we're so delighted that she can be here. She is Professor of Law at Rutgers University School of Law, visiting professor this year at Boston University School of Law. She's the founding director of the interdisciplinary Rutgers Center for Security, Race, and Rights, and author of the book, The Racial Muslim, When Racism Quashes Religious Freedoms. And like our other panelists, a prolific scholar and a leader in her field. Thanks so much for being here. Terrific. So I have asked our panelists to recall that many of our student attendees have no firsthand knowledge of 9/11 and the years immediately thereafter. And therefore, I've encouraged them to be clear and explicit as they can within our time constraints when talking about events and legal developments, and not necessarily speak in the shorthand that we might if we were just sitting in one of our offices talking about these legal issues. We want to help bring our students along. As we know, the generations are turning over in terms of, again, knowledge of that day and the years thereafter. We're going to hear from each of our speakers for about 10 minutes each, and then we'll have Q&A. We're going to wrap up at 4 o'clock. Participants, meaning those of you who are not panelists, will be muted. To ask a question, put it in the Q&A. My understanding is that's the process that's been used on the other panels, and that's been going pretty well. And again, I would just encourage our attendees to be active. I'm going to start us off. We are anticipating another esteemed colleague to be with us to talk a little bit about Congress and the force authorizations, but he unfortunately had a very urgent real world development, and so I offered to step in and talk about those things. So I'm going to say a few words about Congress and about the force authorizations, and then we'll go to Liza, to Peter, and to Sahar. So Congress's performance as a constitutional institution since 9/11 is the focus of a new essay just published today, actually, in the Journal of National Security Law and Policy, as part of their symposium on 9/11, 20 years on. My essay is called 9/11 to 16, Reflections on 20 Years of War, Legislation, and National Security. It's on the Journal of National Security Law and Policy website, and you can find it via me, my handle on Twitter I'm just at Dakota Rudesill. So I'm going to touch on Congress's performance overall and agenda for action with particular reference to the need to revise and replace the AUMFs. Close readers of the Constitution know essentially what is Congress's job. It's right there in the text of the Constitution. In the preamble, it references a more perfect union, ensuring domestic tranquility, providing for the common defense, securing the blessings of liberty to ourselves and to our posterity. This is repeated in Article 1 of the Constitution, which is the article of the Constitution that empowers Congress. Much of this language is there as well. And they're also what we could call the Article 4 commitments. Article 4 of the Constitution, which guarantees the state's protection against invasion and against domestic violence upon request of state authorities. So what is Congress's record since 9/11 in meeting its constitutional responsibilities? My assessment is that Congress's record is pretty mixed. There's some good news. Congress has mitigated the foreign terrorist threat, I think, better than most of us would have expected on the evening of 9/11 or the morning of September 12th, 2001. Everybody feared, or I think almost everybody feared, additional spectacular attacks. Or perhaps worse attacks, perhaps a nuclear weapon in an American city, or massive biological attacks, or something like that. We've not seen that. We've seen other terrorist attacks in the United States by elements inspired by or linked to Al-Qaeda. And certainly there have been attacks overseas, but we haven't seen anything quite as spectacular. So that's some good news. And Congress, I deserve some credit for that. They have abundant authorities under the Constitution for managing the national security apparatus. And so they deserve some credit for that. And they've also done some other specific things that tie into what I just said, but also just there are other things that Congress has done in this national security space since 9/11, which we should note. One of them is that they authorized force after 9/11 against entities involved in the 9/11 attacks. To its credit, Congress rejected the first draft that came from the White House that would have given the president authority to use force against any entity that the president believed was some sort of terrorist entity, whether or not there was a link to 9/11. Congress rejected that, instead wrote something that was textually linked to the 9/11 plotters and those who helped them. Congress created the bipartisan independent 9/11 Commission to do an independent and thorough investigation of the 9/11 attacks. Congress, in a number of statutes, restructured the federal government for Homeland Security, creating the Department of Homeland Security, restructured the intelligence community with creation of the Director of National Intelligence, with an eye to avoiding repeat of one of the problems of 9/11, which was that all the information necessary to identify that the attack was underway was in the system, but the dots were not connected. Information was not being shared efficiently and in a timely manner. Lots of reason to be concerned about the structure of DHS, about the reorganization of the intelligence community. Big and important topics. They're not perfect, to be sure, beyond the scope of the rest of what I want to cover here. But anyway, Congress did that work, and there's been, I think, at least some security benefit from that. Congress also updated the intelligence surveillance regime in a number of statutes. Again, controversial, but they did that work. In response to revelations of torture by the United States government, Congress 3 times statutorily reaffirmed the statutory ban on torture. Congress repealed the don't ask, don't tell policy, which kept LGBTQ Americans out of the military. And in some areas, Congress has done some effective oversight. They did some good work on 9/11, and they did some good work about torture and about the 2016 Russian election interference. So there have been some bright spots. So what's the bad news? Well, unfortunately, there's a lot of it. Congress has done so much worse on domestic terrorism than I think any of us would have hoped or expected, right? And recall again, this Article 4 language in the Constitution on domestic violence, right? The spiraling partisanship that we've seen in this country over the past 2 decades, which members of Congress have aided and abetted, or at least knuckled under to, of course, fed into the insurrection of the Capitol on January 6th of this year. And it was a worse attack for the Capitol in many ways than was 9/11. It came off. It was perpetrated by Americans against their own Capitol. People died. They penetrated the building. Plainly meets the statutory definitions, whatever you think of them, of sedition and of domestic terror. And then a stunning number of members who lined up still to vote for overturning a free and fair election after that. It's just a stunning development that Congress was centrally involved in, right? They were the targets of the 1/6 attack, just as they were a probable target on 9/11. And spiraling partisanship has also meant legislative dysfunction. Many intelligence authorization acts never enacted. Just the legislative process, if you're a student of this, is nothing like what you'd call the regular order. So my recommendations are to do something about this. I think anyone would want something to be done about this. And I recommend two main things. So number one is it is an imperative national security matter that we reduce partisanship in this country. Our political system, our political culture is just rapidly destroying its purposes. I don't see how we can remain on this trajectory and have a country that secures the blessings of liberty to ourselves and to our posterity. How could this continue? And that's a very complex topic, but it needs to be taken seriously, and people need to hold their elected officials account, and they need to feel like they have some agency and some responsibility, and they have a job actually to lead opinion and not simply to put their finger in the wind. And to show some constitutional Congress. That's number one. We imperative that the out of control partisanship and factionalism, to use the Madisonian term, has got to be addressed. Second, there's an agenda for reassertion of Congress's constitutional role in the context of Congress's acquiescence to executive power assertion since 9/11. I mentioned the things that Congress has done, right? But in so many other contexts, Congress has acquiesced to expansion of executive power and left agency really with the agencies, no pun intended, and with the President of the United States. Our students and people who study in this area know, again, Congress has expansive constitutional authorities. The Supreme Court under the Youngstown framework has repeatedly upheld the power of the Congress to write statute that binds the commander-in-chief even in times of war. So the power is Congress's, as Justice Jackson wrote, to assert or to see it slip through their fingers. What more specifically should Congress do? I think pretty clearly, number one, Congress should more aggressively probe executive assertions with regard to intelligence and use of force. The debacle about Iraq and its lack of possession of meaningful weapons of mass destruction was also a debacle for Congress in failure to do its oversight role. Second, Congress needs to rein in standing statutory delegations of emergency authority to the president, about which our panelist, Liza Goitein, has written so thoroughly and so brilliantly. When you read her work on this, it is truly terrifying. The authority is just laying around as the proverbial legal loaded weapons for the president. And Congress needs to revisit the Insurrection Act as well. Third, Congress needs to do some good governance work. There are a whole variety of vital norms that were violated in recent years. And Congress has really not done anything meaningful to address this. They haven't even, something as simple as trying to address use of the security clearance process to punish political enemies of the president, right? Congress has not even done anything on that. They need to get moving on this stuff. Fourth, Congress needs to do something categorical on secret law. This is something that Liza has written about, Peter has written about this, I've written about this as well. And our other panelists are going to talk about the surveillance and torture scandals, especially Liza, in some more depth. But I would just say this, central to both of the most searing national security legal scandals of the past 20 years, the post 9/11 period, has been legal secrecy, has been that in secret, behind closed doors, the law as anybody would understand it, looking at the face of the law was reconstructed in secret to either be bypassed or to read completely different than anybody would understand that law to read. Again, reading what is the public law. Congress has done some limited things with regard to the secret law problem, but hasn't gone far enough. And finally, Congress needs to revisit and it needs to replace the standing force authorizations that are out there. Amazingly, the 1991 authorization for the use of force against Iraq for the first Gulf War remains on the books. I don't think anybody's been too concerned that that's going to be abused, but who knows what a future administration can do. Certainly the 2002 force authorization against Iraq, which was written to authorize the use of force plainly against Saddam Hussein's regime, but didn't say Saddam. It said the threat from Iraq. Well, that statute is still around 17, 18 years after Saddam was driven for power. And to give you a sense of the potential for abuse of just statutory force authorizations that remain on the books, the last presidential administration used a force authorization about Iraq, written about the Saddam Hussein regime, to use force against Iran 18 years after Saddam Hussein was driven from power. Talk about a legal loaded weapon, right? I mean, if we want force, to be legal against Iran, well, Congress should write that then. I'm not endorsing that. I'm just saying that, this is not a good state of affairs. And then we have the post-2001 9/11 AUMF, and we can dive into this more deeply as we go forward too. But so this is a statute written plainly about the 9/11 attacks. It was passed 3 days after the terrorist attacks. I was there at the time, as many of you know. Signed into law a few days later. It was about those entities that carried out 9/11 or gave support to the 9/11 plotters or harbored them. And yet in the years since, to put it kindly, we have seen legal theory creep with this, with under first the theory of succession, which is if there's some sort of entity which is a successor to the entity against which force is authorized, then force can be used against them. So if Al-Qaeda in Iraq grows out of Al-Qaeda after the US invasion of Iraq, and then force can be used against them, maybe. But then if you have another organization, ISIS, ISIL, IS, Daesh, they have many names, right? So ISIS grows out of the rubble of Al-Qaeda in Iraq, and multiple administrations now have relied on that 9/11 AUMF to use force against an entity that did not exist on 9/11, right? And indeed, ISIS at various points has fought Al-Qaeda, which carried out the 9/11 attack. So at some point, these legal authorities go too far. Well, to take it even another hop, the last administration asserted that the 9/11 AUMF provided legal authority to use force against the government of Syria, which had no role in 9/11 of any kind. And that was under a co-belligerence theory, because there were Syrian democratic forces in Syria that were fighting ISIS, against which the government's lawyers had said that, that the United States could use force under the 9/11 AUMF. And then the Syrian government attacks the Syrian democratic forces. So now we can use the 9/11 AUMF as legal authority to go after the Syrian government. And, these are not ridiculous legal theories. I don't want to make them sound that way, but at some point we are so far attenuated from the purpose of that statute and really need to raise questions about at what point does the statute need to be repealed, replaced with something else? If and when it is replaced, we need to ask questions such as, who does this authorize force against? Is there going to be a time limit for the force authorization? Does it govern the means and methods of warfare? For instance, saying no troops on the ground, something like that. And what does it do about the detainees from the war on terror still sitting at Guantanamo Bay, allegedly members of Al-Qaeda and the Taliban? There aren't many of them left, but there's some of them there, including KSM, Khalid Sheikh Mohammed, one of the primary architects of the 9/11 attacks, from what the government has said. Do they, now that the war in Afghanistan, which the AUMF authorized, now that that's over, does he and the other detainees get released, or does a new AUMF be written and have some sort of provision about what to do about these legacy detainees at Guantanamo Bay? Are they held indefinitely under some sort of law of war theory, right? But again, what if the war is over, right? I mean, that would suggest that authority under international law and under US statute to wage the war would no longer allow their detention if the war is functionally over, right? Or maybe the war is not over. Maybe, war with these successors is just enough. These are thorny questions. These are interesting questions. And Congress needs to get on them. It has not done anything really meaningful in 20 years now to revisit that grant of authority to the executive branch. And so I would just wrap up these comments just by going back again to the Youngstown opinion by Justice Robert Jackson, his concurrence, which is the canonical doctrinal statement by the Supreme Court with regard to national security, which is that Congress makes its constitutional powers real by using them. And it is up to the Congress to use that authority that it has under the Constitution to do its work for the country, to provide for the common defense, to secure the blessings of liberty, or to allow that to slip through its fingers to the detriment of the republic. So with those framing thoughts, I now want to go on to our colleague, Liza Goitein, and then we'll hear from Peter Shane and from Sahar Aziz. So Liza, over to you.
Great, thank you so much, Dakota. That's a tough act to follow because you covered a lot of ground. This is very impressive. Well, hello everybody. It's my pleasure to join the Mershon Center at OSU for this very, very timely conversation. And I want to thank Dakota in particular for not just for putting this together and inviting me to be a part of it, but for his leadership in general on the issues we're talking about today, these very, very critical issues of executive power and secret law and so many others. So our panelists focus on the legal legacy of 9/11. I'm sorry to say that in the areas of surveillance and torture, the issues I'll be discussing today, the legal legacy is not a proud one. In both cases, the executive branch decided that the laws in the books did not give the government sufficient leeway to address the terrorist threat. And rather than make the case publicly that the law should be changed, the administration developed programs in secret that violated the law and then came up with legal window dressing in the form of secret Justice Department opinions, the secret law that Dakota was talking about. In both cases, it was years before the programs came to light. And here's where the two stories diverge a little bit. When it came to illegal surveillance, Congress chose to ratify the government's practices, whereas in the case of torture, Congress chose to restrict it somewhat and to conduct an investigation. But the stories converge once again when people harmed by the illegal programs sought accountability in the courts and came up against a judiciary that seems determined not to rule on national security issues. So with that overview, I'll go back and address what happened in more detail, starting with surveillance. On 9/11, there was a law in place, the Foreign Intelligence Surveillance Act, or FISA, that prohibited the government from collecting communications to and from people in the United States without getting a type of warrant from a special court known as the FISA court. This warrant requirement applied when the government wanted to collect phone calls, emails, text messages, and other forms of communications content. The standard was a bit lower when the government wanted to obtain certain information about an American's communications. I'm talking here about phone records and internet records that reveal who you've communicated with, for instance, but not the substance of those communications, sometimes referred to as metadata. But even for those records, FISA required and still requires the government to go to the FISA court and show that the records are relevant to a counterterrorism or foreign intelligence investigation. That's the law. That was the law in 9/11. But beginning almost immediately after 9/11, the Bush administration established a program of surveillance activities codenamed Stellar Wind that violated these legal restrictions. The National Security Agency, or NSA, began collecting communications going into and out of the United States, certain communications, and began collecting Americans' phone and internet metadata in bulk, meaning indiscriminately, kind of everybody's phone and internet records, without getting permission from the FISA court. The unlawful surveillance was conceived and implemented by a small number of handpicked officials in the White House, NSA, and Justice Department. A single lawyer in the Justice Department's Office of Legal Counsel was responsible for coming up with a written legal justification for the surveillance. The head of OLC himself was not allowed to read it. After a couple of years, this intense secrecy began to unravel, as it often does. Hard to keep secrets that closely for so long. Additional Justice Department officials were brought into the Internet Metadata Program and had concerns about its legality. Investigative journalists discovered and disclosed the existence of the other programs. Basically, the illegality, the frank illegality of these programs was surfacing, and it became untenable to continue them in their existing form. This is where the other branches of government stepped in. Unfortunately, their interventions were not a triumph for the rule of law. First, the government brought the internet and phone metadata programs to the FISA court and asked the court to approve them. Now, to authorize this collection under FISA, the FISA court had to rule that the communications records, the phone records of every American, you, me, everyone on this call, are somehow relevant to an authorized counterterrorism or foreign intelligence investigation. And so it ruled. Acting in secret, the FISA court endorsed this bizarre and limitless conception of the term relevance, and bulk collection continued for nearly a decade. When it came to communications content, though, there was no provision of FISA that could be pressed into service in any way. So the executive branch did what it should have done in the beginning, and it went to Congress to ask for expanded authority. But remember now, this is after years of violating Congress's law. And rather than chastise the executive branch for doing that, Congress acted quickly to ratify the administration's unlawful conduct, passing legislation that allows the NSA to collect communications between foreign targets and Americans without obtaining any individualized order from the FISA court. Now, Congress can always choose to change the law and make something legal that was previously illegal within constitutional limits. But the rule of law presumably demands some accountability for past violations. That didn't happen. The opposite happened. When Congress legalized warrantless surveillance, it also granted immunity to telecommunications companies that had cooperated with the government's illegal surveillance. And plaintiffs who sued the government, generally, with an exception that we can talk about later, had their lawsuits dismissed on either standing grounds because they couldn't prove that they personally had been subject to surveillance because it was secret, or on state secrets grounds, with the government arguing that litigation would necessarily lead, any litigation going forward in the case at all, would necessarily lead to the disclosure of information that would harm national security. So I'll stop with surveillance for a minute and turn to torture. And the story of the CIA's torture program has some striking similarities. Once again, the program, and this was, at least originally, this was a CIA program designed to extract information from detainees after 9/11. The program was initiated by a small insular group of executive branch officials who did not inform anyone in the government who they knew might raise objections or legal concerns. Again, this group handpicked like-minded attorneys in the Justice Department's Office of Legal Counsel to develop secret and tendentious legal rationales for the program. Okay. In 2004, one of these memos, these OLC memos, was leaked to the press. And that was the beginning of the end of the torture program. It didn't end right away. Over time, the Bush administration walked back much of the legal analysis in the original OLC memos, but it continued to authorize many of the same techniques. When President Obama took office, he rescinded the torture memos and ended the CIA's interrogation program. In the meantime, as Dakota mentioned, Congress weighed in, passing the Detainee Treatment Act in 2005. This law limited the interrogation techniques that could be employed by the military, and it prohibited any US government official from subjecting someone in their custody to cruel, inhuman, or degrading treatment. It was not until 2015, however, that Congress more specifically restricted the interrogation techniques that the CIA and other non-military officials could use. Another thing Congress did was investigate. The Senate Intelligence Committee launched a multi-year investigation into the CIA's torture program. The executive branch tried to stymie this investigation at every turn, claiming privilege, withholding documents. Ultimately, the CIA went so far as to conduct secret surveillance of the computers used by Senate committee staffers. Despite these obstacles, the committee was able to produce a 6,700-page report with 38,000 footnotes, really just a Herculean product. But it's not clear if anyone will ever read it. 9 years after its release, less than 10% of the report has been declassified. The CIA destroyed its only copy of the report, supposedly by accident, and the Senate Intelligence Committee asked all the executive branch agencies to return their copies back to the committee. President Obama had one copy preserved in his presidential library, and a federal judge ordered another copy preserved in a lawsuit. But to put it mildly, the report is not in general circulation. In addition, no one has been held accountable. The Justice Department has declined to prosecute anyone who acted within the scope of the government-approved program. Multiple civil lawsuits have been brought by the program's victims. Most of them have been dismissed, and none has resulted in a judgment for the plaintiffs. The reasons for dismissal have included these jurisdictional defenses and privileges and doctrines that I was referring to earlier, the state secrets privilege, also in this case, qualified immunity, which insulates officials from personal liability unless they violate, quote, clearly established statutory or constitutional rights, which I guess not being tortured doesn't count as one of those, and a kind of national security exception, basically, to the ability to file lawsuits against government officials. So when we talk about the legal legacy of 9/11, the question I ask myself is, could the kind of breakdown in the rule of law that happened after 9/11 happen again? And what enabled this breakdown, as I've described it just now, was several things. The intensive secrecy with which the executive branch was able to operate, including the secret law, the lack of public access to OLC opinions that constitute the working law of the executive branch, the availability of the Office of Legal Counsel to provide legal window dressing for illegal conduct, the ability and proclivity of the executive branch to withhold information about its activities from oversight committees in Congress, the complete discretion that the executive branch exercises over classification decisions, Congress's squeamishness about acting in the area of national security, and in particular about saying no to the executive branch. And finally, the ever-expanding jurisdictional doctrines courts use to avoid reaching the merits of national security cases. Systemic reforms would be needed to address each of these factors, and those haven't happened. So I fear that if, God forbid, there were another 9/11 or the equivalent in this country, there would be little to stop a president who was inclined to respond with secret unlawful action from doing so. The rule of law was badly damaged by our nation's response to 9/11, and it remains vulnerable today. But it is not too late to change that legal legacy. It's a matter of learning, however belatedly, from this experience, recognizing the factors that enable lawless government conduct and addressing those factors through systemic legal reforms. So I will stop there.
Terrific. Thank you so much, Liza. Peter.
Thanks, Dakota. And let me start by saying it's a privilege to be part of this obviously timely panel with you, Liza and Sahar. You won't be surprised, given our many conversations over the years, that my remarks will significantly echo the thoughts that you and Liza have already articulated in some respects with regard to Congress. You started, however, by mentioning students, so I can't resist saying something about my own 9/11 memory, which is very much tied to students. One of them being my daughter, who had just started her freshman year at NYU and was living in a dorm about 1.5 miles away from Ground Zero. Fortunately, I had a feeling, and I was right, that she was not outdoors at the time, so did not actually see it or breathe the immediate aftermath of it. I personally was, although that got worse quickly, I myself was in my office at Carnegie Mellon University in the public policy school. I was in an office suite, and among the people there was a student. I believe I remember him being a junior, but he could have been a first-year grad student, who was working as a computer programmer on a project of which I was the director. And he came running in. He was the first to have heard of this event. And I think he may have been watching CNN. And he immediately wanted us to leave because he thought Carnegie Mellon might well be a target, given its status as a venue for defense-related research and knowing that another plane had crashed in Pennsylvania. Well, of course, my student's alarm regarding Carnegie Mellon was excessive, but I think he understood more instinctively than I actually how momentous the events of that morning would prove to be for every aspect of American life, including the rule of law, as Liza was just explaining. In terms of the separation of powers, I think many of us will recall the title of Arthur Schlesinger's 1973 book, The Imperial Presidency. has become a kind of canonical shorthand for what Schlesinger, who is a distinguished historian, saw as a modern disruption in the Constitution's intended system of checks and balances. The cause of disruption he was talking about in 1973 were efforts by presidents in the wake of World War II to assert expansive, inherent executive power for which the other branches of government could not call presidents to account. He wrote that the perennial threat to the constitutional balance was in foreign and military affairs. And his examples that he cited for proof were the way the executive branch behaved with regard to Korea, Vietnam, and Cambodia. And the latter, of course, was quite recent and very much in the news in 1973. Schlesinger lived long enough to supply an epilogue for a 2004 reprint of the book, and the epilogue took some account of post-Nixon developments. The imperial presidency, he wrote in one of his sentences, reached what he called a 20th century climax with Nixon. I want to get back to that in a second. But it was 9/11, he thought, that, again, I'm using his phrase, resurrected the imperial presidency in the new millennium. Now, there was, to be sure, a kinship between the Nixon administration and the George W. Bush administration, and now one would add the Trump administration, in their assertion of very expansive ideas of inherent presidential authority. But I think Schlesinger's account of presidential imperiousness, even in 2004, was incomplete. It was, after all, the Reagan administration that marked the beginning of a campaign to resuscitate something we now call Unitary executive theory. This is a theory also embraced by Bush 41, which holds that the president has, if you buy the theory, that the president is constitutionally entitled to control all of the discretionary authority that either the Congress, through its statutes, vests in anyone in the executive branch, not just the president. So what Congress authorizes the Secretary of Defense to do, or the head of the Centers for Disease Control, anybody in the executive branch, if they have statutory discretion, the Reagan administration position was the president is entitled to control it. And even the Democratic presidents post-Nixon, Presidents Carter, Clinton, and Obama, may have not advanced these theories, but none of them added any durable new guardrails against the presidential abuse of power. I want to emphasize, though, another point that Schlesinger noted in 2004, but perhaps underemphasized at that time. And this is a theme that, again, both you and Liza have raised, Dakota, which is Congress's willing abdication of what the Constitution might well be read to give as its primary role, but is certainly a co-equal constitutional role in responding to international emergencies. Schlesinger wrote, Congress and the courts, along with the press and the citizenry, often lack confidence in their own information and judgment and are likely to be intimidated by executive authority in the middle of an international emergency. And he said, the inclination in foreign policy is to let the president have the responsibility and the power, a renunciation that results from congressional and I can never figure out the noun, how to pronounce the noun of pusillanimous, as well as from presidential rapacity. Now, it's been well documented, as far as the Bush administration went, that Vice President Cheney quite purposely and explicitly sought to exploit 9/11 to effect what he considered a restoration of a robustly unilateral presidency in foreign and military affairs. The events are well described in Jack Goldsmith's insider account, The Terror Presidency. Jack, of course, is a law professor at Harvard who was for a while the head of the Office of Legal Counsel during the Bush administration. You can also find an illuminating account in Charlie Savage's important book of investigative journalism called Takeover. Both of these authors discuss the deliberations that led to really the misbegotten attempt to create a kind of law-free zone at Guantanamo, as well as the implementation of electronic surveillance, as Liza described, which had not been authorized by Congress. And in both areas, the administration worked hard to exclude executive branch dissenters from discussions. It should be said that Bush's claims for presidential unilateralism went far beyond foreign affairs. Over the course of 2 terms in office, President Bush wrote signing statements. These are written statements the president signs whenever they sign into law a statute that Congress has enacted. Every statute before it becomes law either requires the president's signature or enactment over his veto by a 2/3 vote. Well, these signing statements actually are not constitutionally compelled if the president approves the statute, only if he objects. But even though the president was signing all of these statutes into law, he wrote signing statements that included about 1,500 constitutional objections to over 1,000 provisions of law that he was signing into law that were spread over 127 statutes. And many involved unprecedented claims of exclusive presidential power based on no legal authority, often enacted in response, and often they were uttered in response to wholly familiar forms of statutory command from Congress, such as requiring the executive branch to issue routine reports on a variety of topics. Yet, in the 2 areas where the Bush administration was arguably most aggressive, regarding access to habeas corpus for the Guantanamo detainees and the pursuit of electronic surveillance, Congress just backed the executive branch's playbook. In the Detainee Treatment Act of 2005, which did have the benefit that's been mentioned of strengthening the law against torture, Congress tried to weaken the access to habeas corpus for non-citizen detainees that the Supreme Court had granted in a case called Rasul versus Bush. When the court, in another decision called Hamdan versus Rumsfeld, held that the 2005 Act did not apply to cases that were pending at the time that the statute was enacted, Congress effectively overruled Hamdan in the Military Commissions Act of 2006 and said, henceforth, there would be no jurisdiction of the kind they tried to eliminate. There were subsequent judicial developments in a case called Boumediene that in some ways turned back this provision of the 2006 Act, but Boumediene turned out not to be, really did not pave the way to any expansive use of habeas corpus to achieve meaningful constitutional accountability in Guantanamo. When the administration's blatant disregard of the Foreign Intelligence Surveillance Act came to light, Congress, as Liza recounted, simply put into statutory form the authorization of the very acts that the administration had performed without statutory authority. The supposed compromise was that Congress, in its new statute, said, from now on, the Foreign Intelligence Surveillance Act would be the exclusive source of authority for foreign intelligence surveillance, which wasn't really much of a compromise since that actually had been written into the original Foreign Intelligence Surveillance Act. It was just a form of statutory redundancy. And this was, and on top of this, they absolved telecom companies from any liability they might otherwise have incurred for helping the administration with unauthorized surveillance programs between 2001 and 2007. And of course, all of this was above and aboard the so-called USA Patriot Act, which was a vast expansion of the government's investigative powers that was enacted pretty much in the immediate wake of 9/11, which really was a wish list of investigative powers, enacted that the Justice Department had sought to be enacted for many years prior to 9/11, and which were not developed at all in relation to the particular needs of 9/11. President Obama, of course, as we know, ran sort of as the anti-Bush, and in office, he typically avoided Article 2 arguments, that is, inherent presidential power arguments, in favor of statutory arguments for his more ambitious initiatives. But he hardly dialed back on executive branch unilateralism in foreign and military affairs. In fact, his statutory interpretation that purported to authorize staying in Libya beyond 60 days was an all but nonsensical interpretation of the War Powers Resolution. And the limits that the administration supposedly acknowledged to the initiation of unilateral presidential war making were hardly limitations at all. In short, 9/11 again revealed executive power to be a one-way ratchet, at least since World War II, always expanding, but at different rates, to be sure, in the absence of meaningful pushback by the other branches. There was a report in yesterday's New York Times by Charlie Savage that there may now be hope of bipartisan support and even White House support for something called the Protecting Our Democracy Act, which would strengthen a number of protections against presidential abuses of power. And there's likewise support for reforming or replacing the War Powers Resolution with a more comprehensive National Security Powers Act of 2021. That act, in theory, would tighten accountability to Congress with regard to military deployments, international arms control, and national emergency declarations. No president since Lyndon Johnson has had Joe Biden's deep experience in Congress, and none has been as involved ever with the affairs of the judiciary, given that President Biden was for so many years a member of and sometimes chair of the Senate Committee on the Judiciary. And it remains to be seen whether those experiences and his sensitivity to the institutional roles of Congress and the courts will actually now lead to some interbranch collaboration in channeling executive power and establishing greater presidential accountability. Thank you.
Thanks, Peter, so much for those comments. So much rich material for us to discuss here. But of course, we want to hear from Sahar before we go to Q&A and discussion. Sahar Aziz.
Thank you so much. Can you all hear me? I've got some internet issues. Or can you hear me? Great. Okay. Thank you for inviting me to this important conference, this timely conference. I am so honored to be here alongside Dakota and Liza and Peter. There's not enough time to talk about how important their work is and what a pleasure it is to be here to contribute to the conversation. And I'm thrilled that the law students are here, and my only regret is that we can't be in person so that we could talk afterwards. It's always the best part of a symposium. Okay, so I'm going to use a PowerPoint, and hopefully that we will not have any major problems with that. And just try this. Doesn't work. Okay, can you see my PowerPoint? Yep, great. Okay. Much of my research, so first I suppose I should introduce my angle. I am one of the infamous, notorious critical race theorists that apparently there's a national movement against. And I've been doing critical race theory unofficially since 9/11, but more officially and formally since 2011, because I wanted to bring that theoretical frame to the national security perspective in my deep research of the civil rights and human rights of Muslims, Arabs, and South Asians, especially in the United States. So I'm currently working on an article in which I will give my preliminary findings, and I'm eager to hear your feedback, called Manufacturing a Muslim Threat, Entrapment, and Sting Operations. And this is focused primarily on terrorism-related prosecutions of Muslims in the United States. All right, so here are just some key points that I will address today. First is that pseudoscientific radicalization literature is essentially or effectively de facto the blueprint for sting operations that are almost disproportionately targeting Muslims, at least from 2001 to 2020. And one of my next pieces will be comparing these findings with prosecution or investigation of far right-wing, so quote, extremists, I'll put in parentheses. I'll talk about the anatomy of a sting operation, which is the key component of essentially getting an indictment and ultimately either a plea or a conviction from the defendant. I'll bring in some preliminary empirical case data on these prosecutions, and then I'll give a very brief overview of the doctrinal failures of entrapment law, which is supposed to protect defendants from the type of overreach that I argue has been pervasive over the last 20 years. And a large part, I think, of the overreach is because of the racialization of the communities, the stereotyping of these communities, which then creates almost a license, a political carte blanche to run roughshod over their rights, because very few people will be concerned or think that it will affect them. Because when you're talking about 3 to 5 million people out of 350 million, it's not as if they can go to the polls and influence politics in that way. Okay, so with regard to radicalization theory, and there's a lot out there, and I will say much of it, in my opinion, is, well, it's unfounded. It's not grounded in empirical evidence. That's not even my opinion. That's pretty much the consensus among all of the scholars. And this tends to be found more in the terrorism studies, which is kind of a cross between law and policy. But there are different models that have been put forth, all of them to no avail, because nobody can figure out how do you identify a terrorist so that you can prevent terrorism. And that's ultimately the objective. So one is there's the structural socioeconomic political model frame. And these scholars tend to look at what we call the root causes of terrorism, such as poverty, lack of education, authoritarianism, human rights violations, political oppression, inequality. And they also tend to attribute terrorism to the terrorists holding some form of ideology that motivates them, such as religious fundamentalism, Marxism, xenophobia, hypernationalism, racism, etc. The problem with these models is the question, there's always 99% of the people who fall under the group don't engage in political violence, whether they're poor, whether they have a low education, whether they live in an authoritarian society. And so there's nothing that empirically proves that this is in fact what causes someone to become a terrorist or engage in what we call politically motivated violence. And similarly with the ideological frame, and I think the easy example in the so-called, I put in parentheses, Islamic terrorism, I don't call, it's not Islamic terrorism, right? It's terrorism based in Afghanistan, terrorism based in Palestine, Israel, terrorism, right? Because there's only, what's the percentage of people who actually join these ideological movements compared to the 1.5 billion Muslims in America? Tiny, right? 0.0001. That's not to say we don't ignore them, but when you're trying to be engaged in predictive policing or preventative counterterrorism, you got to think about that. The next is what the scholars call the psychological models. And that tends to look at, there's the psychoanalytic that looks like is the person narcissistic or paranoid or some kind of neurosis that they have. Or there's psychological profiling theories that individuals may be emotionally vulnerable, they're dissatisfied with current political or social events, their perceptions that nonviolent political action will not effectuate change. They identify with the victims and their real or perceived grievance. And so again, this is when counterterrorism expert or enforcers are trying to find a psychological profile, again, to try to identify potential terrorists. And then finally, there's the social psychology theory, which looks at individual risk factors, right? Identity crisis, experiences with discrimination, lack of social integration. But again, the problem is there's just no empirical data. There have been many studies done in the terrorism studies, social science world, and I spent a significant amount of time over the summer reading the literature, and there's a very extensive literature review of my forthcoming article. And it's clear that if there's one thing that everybody agrees on is nobody knows what the causes of terrorism are. They're multifaceted, they're complicated, they're very context specific in terms of time, space, culture. And I know that's not what policymakers want to hear. And then there's the social network theory, which is the one that has, I argue, taken root in the American counterterrorism community. And many people have heard of Mark Sageman. He's considered a big expert, especially in the US context, but arguably also in UK and other European contexts. And so one model he has is the bunch of guys model. And he essentially claims that social contagion among friends and social networks is what causes the proclivity to engage in terrorism from the power of the group. And so therefore, there are 3 steps. There's the socialization process of friendship and kinship, progressive intensification of beliefs leading to acceptance of, in his view, the Salafi ideology, and a link to know-how and support. And this social network theory is effectively what I found based on my research of the empirical cases, is what I believe has become the de facto blueprint. And what the government has done over the last 20 years in order to inflate its conviction and plea rates is to model this through informants and undercover agents in sting operations, who will create this bunch of guys, who will create the social network that then entraps, if not de jure, most certainly de facto, their target. Okay. So let me just kind of show you a little bit about the cases. So there are 562 federal cases. There were approximately 10 to 14, I don't remember exactly, that were state cases, mainly in New York. But to no surprise, we all know, anti-terrorism enforcement is in the federal space, and most of the laws are federal laws. So 562 cases, and again, I limited them to only those who were defendants that self-identified as Muslim. Second Circuit, to no surprise, right, with New York, District Courts of New York are located, has the largest, and then followed by the Fourth Circuit, which covers Washington, D.C. But also you'll notice that there's a healthy number in the Ninth Circuit and in 11th Circuit and in 6th Circuit. And then the lowest numbers are in the DC Circuit is the 6th. The 4th Circuit is Virginia. That is because of Virginia. And then the 10th Circuit is low. Now, again, this matters